Well, hello, everybody, and welcome back to Raw Law Unfiltered with your host, the DUI Guy Plus. Today, I'm going to be doing something quite unusual. Many of you have been sending in requests for things you want to see. Many of you have been emailing me about certain things that you want me to cover on my channel. And one of the things that I think has gone completely unsaid and undone by any member of the defense bar across this great nation, in any state, in any jurisdiction that I can think of, and that is the revealing what exactly goes on behind the curtain. And you might be sitting there thinking and going, Larry, isn't this going to undercut like your own business and your own profession and your own ability to maybe get certain types of clients? And the answer is yes. Yes, it will. But I'm still going to do it because I don't care. I think information should be disseminated, and it is important for the public to know what goes on, like I said, behind the veil. So, without further ado, let's dive right in. There are 10 items that I'm going to be covering, and there's a PowerPoint slideshow to go along with them. So feel free to follow along. I'm going to go as quickly as reasonably possible. So, number one, first and foremost, the most important thing, and there's the reason it's number one, and it is the only thing that is going to be in all caps because there is nothing more important to you and your case than being nice to the clerks at the courthouse. No matter what jurisdiction you're in, doesn't matter which courthouse you are in, where you are in this country, the clerks need your nicest behavior. Here's why. Clerks deal with nonsense and bullshit day in and day out. They have to deal with lawyers. They have to deal with judges. They have to deal with prosecutors. They have to deal with members of the public. And a lot of them tend to be sometimes, not always, unruly and a little bit difficult to deal with, difficult to manage, difficult to, keep in check. Tensions are high. People's freedoms are at stake. Sometimes maybe not even freedom, maybe just so much as a criminal record. Be nice. Be gentle. You will be amazed at how much you can get in exchange for just a simple thank you and a polite gesture or a smile from a clerk. Because make no mistake, the clerks are the ones who are running that courthouse. Not the judges, not the prosecutors, not the defense attorneys. Without the clerks, the whole system would collapse. So be nice to them. Bring them a bar of chocolate or something. You'll be amazed how far that will go and how far that will take you. Number two, sometimes in certain jurisdictions, if you come in and you have a low level case, let's say it's a low level misdemeanor or might be a traffic offense, sometimes you may get the same offer, maybe even a better offer than if you had gone to court yourself versus had you gone to court with an attorney and paid an attorney. Not always. Again, not all lawyers are born the same. Sometimes you do have attorneys that will walk in and their reputation precedes them, and they may get an offer that may not be available to some other attorneys. Not always the case, but sometimes for small level traffic offenses, small level misdemeanors in most jurisdictions, I have seen from personal experience prosecutors sometimes giving out offers to the general public, whereas almost exactly the same as they would have given if a lawyer had been present. So it saves you maybe a few $100, really, no more than. This only applies to simple level cases, simple misdemeanors, simple traffic offenses, things like that. And again, not in all jurisdictions. Some jurisdictions, sometimes it's just the fact that you brought a lawyer in. It's like, all right, you already paid your price. Here's a dismissal, or here's an amendment, or here's an offer you can't refuse, some type of diversion or deferred prosecution. I've seen that happen as well. It all depends on the case, the jurisdiction, and of course, who the lawyer is or isn't that you have or have not hired. So keep that in mind. Number 3, always, always, always set your case for jury trial. Why? Because there's no reason not to. Okay, we'll come back to this point again very, very shortly about prosecutorial conduct and why you should make them work for it. But setting your case for trial, I mean, there is literally no reason whatsoever for you not to ask the court to set your case for trial. Whether you believe you did it, whether you believe there's enough evidence there, whether you believe that you are innocent, it does not matter, because the system is a very, very fragile system, and defense attorneys worth their salt will tell you this day in and day out. If everybody set their case for jury trial, literally every single person in this country would set their case for trial, the system would collapse. There's no question about it. It's just people are scared. They don't know what they're doing. The offer is on the table and they just take it. Why? There is absolutely no reason not to set your case for jury trial. And if and when you do, now you're putting pressure on the court, on the prosecutor. You have now potentially taken an afternoon of calling cases and reserved it just for little old you to call in your witnesses, to make the government work for it, which, like I said, we will come back to. So there's no reason not to set your case for jury trial, especially because, and I speak from experience, a lot of times prosecutors will wait until the day of or the day before and may make you an offer you can't refuse, just because they begin preparing for the trial, they begin preparing for the case, and they begin to realize, you know what, my case may not be as strong as I may have suspected, and I don't know if I want to go up against a pro se litigant, meaning a litigant who's not represented by an attorney, and go head to head and potentially lose and get an acquittal. So I'll just give you something, that you are going to be happy with. I'm getting what I want. You're getting what you want. Everybody walks away happy. But you don't have that leverage if the case is not set for trial. Make sense? Number 4, public defenders. As much as I absolutely love and respect public defenders, you have no idea how difficult their job truly is. You have no idea how hard public defenders work for you. They are understaffed, overworked, underpaid, underappreciated. They don't have time for themselves. They barely have enough to live on in most jurisdictions. And yet they have more cases, more stress, more work, and more clients to shake a stick at than you would have to be able to deal with as a public defender. They have more cases than any private attorney in the universe. And that makes their job very, very unique, okay? Public defenders, from what I have seen, they will devote their time, and please correct me if I'm wrong in the comments below. I'm speaking from experience, and every jurisdiction is different. Public defenders will usually allocate the bulk of their time to the high level felony level offenses. So I don't want to get this video demonetized, so I got to be careful what I say. But essentially, when you unlive someone, if you take physical advantage of someone, if you burglarize someone, if you rob someone, those levels of crime are usually given the utmost attention and the utmost time by public defenders. Okay, because those are the felonies where the client is potentially looking at 5, 10, 15, 20, 40 years in prison, or a potential life sentence, or possibly even the death penalty. So those cases, public defenders are going to allocate usually again, if you have 400 cases and 10 of them are, I mean, some departments have, I believe, capital punishment departments that only deal in capital punishment. But still, anything short of that, anything below that, public defenders, because there's only so much time. It's not a diss. It is not a hate towards them. To the contrary, I love our public defenders. Our system would also collapse without them. They are the gatekeepers. They are the guardians of the Constitution, much like ourselves. And they take the cases no one else wants, and the clients cannot afford when they can't afford an attorney. And so they have the burden. And when they're given these low-level misdemeanors, unfortunately, and this is the reality, they are not going to have time to spend to review your little shoplifting at Walmart case. No offense. Okay? They're just going to get the first available deal that is going to be put on the table and probably pass it on in the 5 seconds that they're going to spend with you. That's just the reality. And so either representing yourself might be prudent, or hiring an attorney if you have the means to do so. So public defenders are best for high-level felony cases. Next, number 5. If you are choosing to represent yourself, you have a right to file motions. You have a right to file motions for discovery. You have a right to file motions for suppression of evidence. You have a right to file motions for preservation of evidence. You have a right to file FOIAs, which is Freedom of Information Act requests in some jurisdictions. In some jurisdictions, FOIAs replace motions for discovery in their entirety. So it depends on where you have been charged. Now, be careful, okay? Be careful. Make sure you are following the local rules when you are making requests of the government to turn over the information that you are seeking in order to get the information itself. Because if you're going to be violating court rules, basic court rules, in order to try and extract information from the prosecutor, you're going to look foolish, you're going to look unprofessional, and you are going to be laughed at and scoffed at. And you know what? For right reasons. So follow the rules. Download the manual. They're almost always available online, especially in the bigger jurisdictions and even the medium ones. And you will have a chance to review the local rules, the local court rules, on what is the following, the proper procedure that you must follow in order to get the information that you are looking for from the government. And if you follow proper procedure, believe it or not, the court will appreciate it. The prosecutor may not like you, but they will appreciate it as well. So you have a right to get all the evidence that the prosecution has on your case, whether you have a lawyer or you don't. And it's also very important to note, by the way, sad reality that we live in, a lot of lawyers will not even go so far as to gather your own evidence for the case. Believe it or not. So make sure you hire a lawyer that is going to be taking care of you and not just taking care of your money. Next, number 6. I told you we're going to be coming back to this point. Make the prosecutor earn their guilty plea. I'm going to say it again because this is so important. Make the prosecutor earn their guilty plea. What does that mean? It means at your arraignment or at your first pretrial conference, when you come to court, let's say you are representing yourself, and the prosecutor floats over an offer. Look, if you just plead guilty today, I'm going to give you no jail time. I'm going to give you all this good stuff. You're just going to pay a fine. But what they don't tell you is you're going to have a permanent criminal record, maybe subject to expungement depending on the jurisdiction, 5, 7, 10, 12, 15, 20 years. Some jurisdictions like Texas have no expungement, Once you have a criminal record, you have a criminal record for life. You're branded for the rest of your life. And also, expungements in a lot of jurisdictions are a creature of statute. They're only applicable to the state where they are happening. So at the NCIC level, which is the federal level, FBI, CIA, and so on have access to that. The National Crime Information Center, for those of you unfamiliar with the acronym, NCIC, good luck getting that erased from the NCIC record. That is probably never going to happen. So, although on the state side, all the records will be destroyed, your employer will never be able to find out about your past criminal history if it's been expunged. It's still out there. It's still out there in the NCIC database. So, in order to avoid that, and rather than having to call a lawyer after the fact and saying, look, I messed up, I pled guilty to blah, 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 and now I don't know what to do. In order to avoid that, meet it on the back end, on the front end rather than the back end, and tell the prosecutor, look, I am not pleading guilty to this as is. I'm going to set my case for jury trial, as some lawyer schmuck on the YouTubes told me I should do, named DUI guy or something like that. And I'm going to make you earn your guilty plea. So I'm going to prove my innocence at trial, and let's go ahead and set this case. And there's nothing the prosecutor can do. There's nothing that the prosecutor can do. The prosecutor is under a constitutional obligation to set your case for trial. Now, I know, and I've heard horror stories in very, 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 very few jurisdictions across our great nation. Very, very small. I'm talking like population 2,000 or less, which may never even be able to see this video. Maybe they'll hear it from somebody. Some judges don't do jury trials. I've actually heard that in my career. Not in Kentucky that I know of. I don't think we've ever had that situation. I think this one was in Arkansas, the particular situation that I'm thinking of, in a very, very small county where they literally have one day where they do jury trials, 365-day calendar, and they stack all jury trials on one calendar date. I'm talking 364 days, no jury trials, one-day jury trials, and they will have like 50 of them scheduled for one day. And of course, you can't have 50 jury trials in one day, and they have something known as plea and appeal in that jurisdiction. And what that means is you just plead guilty and then you appeal the judgment, which I think is complete nonsense. I don't know, it's 100% unconstitutional, but it's the judge's courtroom, and they get to do whatever the heck they want in that courtroom. So if you're in that situation, good luck. You're definitely going to need to appeal your case and hopefully win on appeal. But then I always wonder what happens. So you win your appeal, the case comes back, the court says you reset it for jury trial. What are you going to do? Plea and appeal again, over and over? I don't know. I don't know. That I don't have personal experience with. This is a story that is not mine, but that is definitely something that I've heard of. So make sure that you make the prosecutor earn their guilty plea. Don't just hand it over on the silver platter to the first available offer, because you know what? Offers get better with time. And especially if your case is set for jury trial, offers are going to get better the closer you get to that jury trial, the day before, the week before, the day before, the morning of, right as the jury is potentially about to be walking in. And you never know. A lot of times, my favorite line from the internet is, can I win my case if the cop didn't show up? The answer is sometimes. It depends on what stage the litigation is in. Because if this is just a pretrial conference, sometimes officers are not even subpoenaed to show up. So you're not going to win just because the officer didn't show up. The only time that is applicable is going to be for a hearing or for trial. Okay? So if the officer is subpoenaed to appear for jury trial and the prosecutor is ready and they're gung-ho and they're like, let's go, and they got their folder and they got their other witnesses and everything, but their star witness doesn't show up, the police officer, you can move for a dismissal for the Commonwealth's or the state's failure to announce ready. Did you know that? That's how you win when cop no show. Okay? So make the prosecutor earn their guilty plea, and you know what? You might accidentally win. Next. Number 7. I cannot stress this one enough either. Make sure that when you file your motions, make them look professional. Make sure that they are typed, that they are styled appropriately. Which courtroom are you in? Which courthouse are you in? What judge are you in front of? Um, Make sure that they look professional. Make sure that they are uh, typed in accordance with the rules. Don't handwrite them, especially if your handwriting is chicken scratch and the judges are not going to be able to read them. It's very, very important that everything that you make looks as if it came from an attorney or as close to, if you're going to be representing yourself. Also, plagiarize. Plagiarize, plagiarize, plagiarize. This isn't grade school. This isn't college. This isn't law school. Okay? Plagiarize. Copy other people's work. Steal it. You know how much work we attorneys steal from each other every day? Copy each other, plagiarize from each other. Hey, I have this kind of case. Does anybody have a motion? And yeah, absolutely. Here you go. Okay, thank you so much. And you just change it up and make it appropriate to your case, to your fact pattern. Happens all the time, especially for young attorneys. You think we start creating all of our work from scratch? You're not getting graded. This isn't school. Nobody cares. Steal it, cheat, plagiarize. It's all permitted. You're not going to get points deducted. To the contrary, you may actually be rewarded for your plagiarism. Welcome to the real world. Number 8. When you're charged with a misdemeanor, like a high-level misdemeanor or a low-level felony, remember I said public defenders don't have enough time to allocate to take care of all of their cases. Not their fault. The system is flawed. It has flaw in its design. It has flaw in its construction. It is not perfect. It has a lot of defects. One of those major defects is piling on all those clients who cannot afford an attorney, but by law have to have one, okay, are assigned to the public defender. The public defenders are, again, overworked, underpaid, overstressed, and undervalued. When they're given these cases, they try to get them off their back as quickly as possible. And can you blame them? I can't. I would probably do the same if I were in their shoes, because you only have so many hours and minutes in the day, and you want to go home at 5 o'clock. You don't want to be working every day until 10 p.m. You know? So in order for them to have a real work-life balance, sacrifices must be made. And unfortunately for you, if you have a low-level misdemeanor or a high-level misdemeanor or a low-level felony, you're probably not going to have the public defender allocate as much time as you would have liked. And that is okay. But as long as you are cognizant of it, you understand it, and you're aware of the consequences, then by all means, go ahead. But if you're able financially to hire an attorney, I strongly urge you to consider hiring one, because we will be able to allocate more time, more energy, more attention, and bring more value to your case than if you were to represent yourself or have the public defender. That is just a fact. That's just reality. Number 9. Remember what I said about high-level felony cases. Public defenders definitely, in my experience, from what I have seen, have time for those. I mean, you got to put your time somewhere, right? Person is looking at 10 years in prison, 20 years in prison, 40 years in prison, life sentence, death penalty. they're going to allocate their time. And some of them will probably have more experience than some private attorneys I could mention. That's also just a simple fact because they get so many of them. And a lot of people resort to those high level felonies because they're trying to make ends meet. And that is the only way they see themselves being able to get out of the situation that they're in. Very, very unfortunate, but c'est la vie. Such is life. If, however, you are still in a position, maybe you're caught in the cogs of the machine, maybe you are wrong place, wrong time, whatever it may be, whatever your story is, and you are able to hire private counsel on your high level felony case, by God, do so. Because once again, just like I said about point number 8, we're able to allocate more time, more energy, more effort into your case than anybody else. And last but not least, the only person, the only person in that courthouse that may potentially care more about the case other than you, because it's your case, it's your future, it's your life. You know the story, you were there, whether you did it or not, whether you think you're guilty or not. As I like to say, just because you did it doesn't make you guilty. Nobody cares about your case more than you. But if you can find a lawyer who is going to be equally empathetic, because you will never find anyone who's going to be more empathetic to your story than you. That's just reality. But if you can find a lawyer who's going to be at least equally empathetic to your case than you, by God, hire them, because they're the only person in that entire courthouse that cares. To the prosecutor, to the judge, to the police officer, you're just money bags. You're just a number. You are a check that they're trying to cash. They're trying to get you to sign on the dotted line. That is the guilty plea form. Just plead guilty, take your punishment, pay the fine, pay the court costs, and go home. That's all they want. That's all they care about. They don't care about the consequences of this guilty plea on your life. They don't care about the consequences of this guilty plea on your employment, on your possible immigration status, on your possible citizenship status. All of those could be affected. So nobody in that courthouse cares about your case more than you do. So take care of it. Don't just treat it like some other stepping stone in your life. Take it seriously. And if and when you do, you might be surprised by the results. Even if you represent yourself and you style your motions correctly and you style them appropriately and you follow the rules and you file them correctly and you ask for the evidence and you get the evidence and you appear for court and you dress appropriately for court and you're nice to the clerks and you set your case for trial, good things might happen. I hope that you learned something. I hope that this has been educational. I've been wanting to do this series. Well, it's not really a series, it's more like an episode. But I wanted to do this episode for quite some time now. I just didn't know exactly how to formulate it. And I think I finally got it. And I hope you enjoyed it. I hope you learned something. Spread the word, share the wealth. Believe it or not, even though you may have been watching this going like, I don't know, this seems cute, seems like it's pretty informative. But I don't know if anybody can find this useful. Believe you me, when you and if you are caught in the cogs of the machine, the information in this video is based on 10 years of experience of a criminal defense practitioner who has seen just about everything and heard just about everything. There is no other video out there like this on the internet. And I wanted to make it because if not me, then who, right? So I hope you learned something. I hope that you are going to be able to take something from this. And I will see you all in the next video. Have a wonderful rest of your day. I love every single one of you. Until next time. Bye, everybody.